Criminal and Civil Procedures module. There are 9 lessons with their corresponding desired objectives to be achieved by participants within this module. At the end of these short lessons, participants should be familiar with the basic factual information applicable to criminal and civil procedures in the United States as well as the state of Ohio. Of course, we have to have a disclaimer, right? All the information provided in these short lessons is publicly available and provides a simplified view of the criminal and civil procedures in the state of Ohio for participants to gain a basic understanding. Remember, procedures vary across jurisdictions, so it is important to always check the steps in the process of the jurisdiction you are working. This information is not intended to be construed as legal advice. Participants will also be able to identify key concepts along with their corresponding legal terminology and know how to use them appropriately. Participants will also be provided resources to complete the individual assignments and are encouraged to use the same to build personal glossaries by incorporating the legal terminology used in these lessons so they can interpret them correctly and use them appropriately into their working languages. Lesson 9. Civil Case Flowchart. The objective here is for participants to gain a basic understanding of how the civil case process works in the state of Ohio. As you can see from this template of the sequence of how a civil case flows through the courts, it can be very complicated, and there are many steps that occur from the time a complaint or petition is filed in the appropriate court to when the case is over. Just like with the criminal process, the Ohio Rules of Civil Procedure outline all the steps in the civil process. Similarly, we recognize that every civil case process has its own series of steps depending on the type of case it is. In this lesson, we're going to get a general and simplified idea of the way a civil case moves through the courts in Ohio. There may be instances where some of the steps do not apply or may seem to be out of order, but they are mentioned in this lesson nonetheless. For specific details about the order of the steps, it would be necessary to consult an attorney with the particulars of the actual case involved. Individual activity. Visit this Ohio State Bar Association YouTube channel for additional resources and information regarding the Ohio case law and legal matters. You can enter the following link in your browser, or you can run a web search for the Ohio State Bar Association YouTube channel. Most often, the civil process starts when the complaint or petition is filed in court, depending on the nature of the case and the dollar amounts. In other words, here is where the plaintiff or the defendant describes the perceived action that leads to the suit. The decision of where to file must also take into consideration the jurisdiction and venue, since a court must have the authority to decide the case. It is often the attorney for the party who initiates the suit that would provide legal advice about where to file. However, the court clerk's office is usually a good place to start if one does not know, because they will provide you with the necessary information or direct you to the correct place. Next, part of what the plaintiff also files with the court clerk is a request known as a summons or notice to be issued on the defendant so the defendant can be served. That means the defendant will now be notified there is a complaint or lawsuit against him or her. Depending on the jurisdiction, the summons could be served by a deputy sheriff, a special process server, or even by U.S. Postal Service. Please note, depending on the area of law, the person who files the complaint is the petitioner, and the person against whom the complaint was filed, that is, the person who would have to answer to the complaint is the respondent, such as is the case in domestic relations. There are time requirements for the person who was served to file an answer, but basically, this is when the individual admits or denies any allegations made in the complaint. Here is also where specific pleadings, motions, or counterclaims can be used by the defendant as a defense. The CNO Legal Glossary states, discovery, procedures used to obtain disclosure of evidence before trial. For an in-depth look, please refer to the Ohio Revised Code. Basically, in civil matters, discovery is the pre-trial phase in a lawsuit with a broader scope than criminal procedures in many instances, allowing the parties, generally known as the defendant and the plaintiff, to a civil action, to ask for pretty much any material or information that could reasonably help lead to the discovery of admissible evidence. The rules of civil procedure provide the guidelines for how the parties can investigate the facts of the case. Depositions, interrogatories, and requests for production are some of the methods used. If there is insufficient evidence to support the complaint, the case gets dismissed by the court. There could be a dismissal with prejudice, which is a court action concluding a case that prevents an identical lawsuit from being filed later, or a dismissal without prejudice, which is a court action concluding a case that allows a lawsuit to be filed later. Another way to end a civil case before going to trial is for the parties to reach a settlement. In a settlement, either side has a chance to settle the issue before going to court or use an arbitrator if that jurisdiction requires it for certain kinds of disputes, for example, child custody disagreement. Not many of the lawsuits filed end up going through the entire process because a settlement is not about who is right and who is wrong, nor is it an all or nothing situation. A settlement can be reached at almost any part of the process. A basic definition for a settlement is an agreement by parties to a lawsuit to resolve their dispute without having a trial, according to the CNO Legal Glossary. For a basic definition of a trial, you can use the CNO Legal Glossary, which defines a trial as a formal court proceeding in which a judge or jury decides disputed facts and determines guilt or liability based upon the evidence presented. An even simpler definition, according to the Glossary of Commonly Used Court and Justice System Terminology, states a trial as a judicial examination and determination of issues between parties before a court that has jurisdiction. The general aspects of courtroom procedure that work in a criminal case would most likely also work for a civil case. In some civil trials, you will also have pretrial conferences, motions for summary judgments, or even post-trial motions. However, for the specific functions of a civil trial and any differences as compared to the criminal process, it would be best to either talk directly to an attorney and/or consult the rules of civil procedure together with the Ohio Revised Code. The final judgment entered by the trial judge is what either grants some or all, or denies whatever relief the plaintiff was seeking. The CNO Legal Glossary indicates an appeal as a request made by a party that has lost on one or more issues for a higher court to review the decision for correctness. Similar to criminal procedures, civil appeals have a very strict process and are best left to be explained by an attorney. The key points to remember in Lesson 9 are: the steps in the civil process in Ohio depends on the nature of the case and what is being sought, which lead to considerations of jurisdiction and venue. Individual activity. Complete the exercise. Identify the general steps in the civil process flowchart in the state of Ohio and provide a basic definition of each. End of Lesson 9.